Welcome to For Better or For Court, Family Law in New Jersey.
Welcome back to For Better or For Court, Family Law in New Jersey with Miss Alex Claps. Alex is a partner at Heyman and Fletcher and a certified matrimonial attorney, helping New Jersey families navigate divorce, custody, and complex family matters with clarity and care. I'm Evan Mack, and today we're talking about an important component of divorce in New Jersey when alimony comes into play and what it looks like under different circumstances. Alex, my dear, welcome back.
Hi, how are you, Evan?
Well. Now, New Jersey officially overhauled its alimony laws in 2014. How did this change the landscape for long-term marriages, and what replaced the permanent designation?
Right. As you know, in 2014, we did away with what we called permanent alimony, and we replaced it with something called open durational alimony. If your marriage is longer than 20 years at the time of your divorce, there's a presumption that there's going to be open durational alimony, which lasts until the payor reaches full Social Security retirement age. That's all a presumption. So it's not a hard and fast law. There are things that we look at that determines that. The biggest difference between open durational and permanent is that permanent used to last until death. So it didn't matter necessarily that the payor was retired and maybe on limited income, only receiving Social Security or living on retirement assets that had also been equitably distributed. So that was one of the reasons why it was necessary to overhaul the statute, because there was a double dipping aspect to alimony post the payor reaching full retirement.
Is there a rule of thumb or a specific calculator for how long alimony lasts based on the length of marriage, or is it entirely up to the judge's discretion?
There's discretion, and there's no, other than the 20-year, which is a quasi-bright line, and even that, there's always some gray area. Like if you file on the 360th day of the 19th year of your marriage, I don't know if your argument that there was a less than a 20-year marriage is going to hold any water, because you're right there on the cusp. But it's the everywhere in between that it's really interesting. So my personal sort of guidelines, and these are not written in any law, is if it's less than 5 years, there's probably not much in the way of alimony. If you're somewhere between 5 and 15 years, there's probably a limited duration alimony. It's when you get above between 15 and 20, you're looking at, is it 8 years of alimony? Is it 12 years of alimony? It's how long should that limited duration be? Because the longer you've been married, the more you have this entrenched marital lifestyle, which usually comes with a discrepancy in income.
You kind of touched on it, but for marriage lasting over 20 years, what exactly is that open durational alimony? How does it differ from that permanent style you were mentioning?
So the biggest key for open durational is that it presumptively ends when the payor reaches full retirement age. So for most people who are getting divorced now, that's age 67. If you're the payor and you reach age 67 and you actually retire, then you get to ask the court to eliminate your alimony. The key is, in many cases, the open durational length, depending on the age you are when you get divorced, can be less than the term of the marriage, even though you've been married more than 20 years. So if I go in at age 52 and get divorced, I'm only 15 years away from the anticipated end of open durational alimony. There are other exceptions too, because Social Security retirement age is the retirement age expectation for people in a lot of white collar jobs. But you get union plumbers, union electricians, people who are destroying parts of their body through their job. Police officers. How many police officers work to age 67? Almost none. So if you have a retirement in good faith before the age of 67, then you can argue that your retirement is in fact full retirement age for your profession. And you might be able to lower your alimony or eliminate your alimony earlier based on that's a job that you had during the marriage. Your anticipated retirement date was always earlier.
New Jersey, emphasizes, maintaining the marital standard of living. How do you realistically calculate that standard when one household is splitting into two households?
I think it's an acknowledgement that a lot of people make when they're getting divorced. No, neither of us is going to actually be able to maintain the marital standard of living. That takes a lot of money, and it takes a marital standard of living where you weren't living at or above your means. But you usually state to the court, no, neither of us is living at the marital standard of living. We still want to get divorced. And as long as the marital standard of living hasn't gone like this, so one is way below and the other is maintaining the marital standard of living, as long as it's equitable, you're both basically taking the same kind of haircut, that's acceptable. The goal is the marital standard of living, and we use the marital standard of living as a guideline, but it's also not annual household income isn't the magic marital standard of living. It's, are you lower middle class? Are you upper middle class? Are you living a high earner lifestyle whereby you own a vacation home or something like that? Like that, it's a category more than it is an absolute income amount.
New Jersey uses 14 specific statutory factors to determine alimony. Which 2 or 3 of these usually carry the most weight, in the courtroom, in your opinion?
Yeah, I mean, I could not stand here and recite all 14 to you because a lot of them are not relevant, or a lot of them mush together into a large thing. I look at what were everybody's earnings and what was everybody's role during the marriage. So if you have a spouse who did not work outside the home during the marriage, that's a component of a need for alimony, because even if they go out and get a job now, you can't have the same earnings expectation for them. The age of the parties, the length of the marriage, those are all important. The differential in incomes, earning capacity, those are important. Expected retirement age, illness. If somebody has a degenerative illness, if somebody is disabled, those are things you have to keep in mind. Responsibilities for children. Are we talking about a divorce that's happening while we still have preschoolers, or are we talking about a divorce that's happening now that the children are in college? Because that also changes everybody's ability to earn. You look a little bit at, well, what are the other assets we're dividing? Is somebody getting the house in lieu of alimony? Are we giving them a lump sum instead of giving them monthly alimony? And everybody's okay with that. Or are there assets that everyone has, investments that people are getting income from that isn't earned income but is more passive income, that we have to look at when we're looking at what is the actual differential? So we're not worried about earnings capacity, we're worried about income levels. Those are the ones I look at. Some of them don't, like some people don't have retirement assets. Some people don't have investment accounts. So all that goes away, and then you just look at people's ability to pay their bills. When you're looking at alimony, you basically look at marital lifestyle, the need for alimony, and the ability of one party to pay alimony.
So what happens if a spouse purposefully takes a lower paying job or quits entirely to avoid paying, or receiving more alimony? How does the court, impute income?
That's the magic word, impute, because courts don't look kindly on people who sandbag their income for alimony planning purposes. There's a whole history of case law where, if you're going to take, let's say you in good faith take a lower paying job because it has better long-term prospects for you. Great. The court's going to say that's fine, but you're still going to be held to the income level that you could be earning now, because you're going to earn more later. Now, I'm not going to impute you with what you're going to be earning down the road, but this is a strategic choice that you're making for the betterment of your own future, and you don't get to punish your spouse because you're suddenly making half the income for a couple of years that you were during the marriage. Similarly, if you come to me and you have been a stay-at-home spouse, or you have worked part-time, my advice is never going to be, don't go out and find a job. My advice is going to be, go out and find a job now, because we need to know what your earnings capacity is. Even if you get a little less in alimony, you're going to have a higher level of income overall by having your own job. And we're going to be able to demonstrate to the court exactly how much you can make, instead of ending up with an imputation that may be too high because we assume what the job market looks like. It's safer to have real numbers.
At what age can a payor kind of typically stop paying alimony in New Jersey? Does the reaching Social Security age automatically trigger an end to payments, or not?
There's a rebuttable presumption that when you reach full Social Security retirement age and you actually retire, that your alimony ends. It's a rebuttable presumption, though, because if you reach the age of, in most cases, 67, and you continue working, well, the court's going to say, no, you don't get to end your alimony obligation because you're still working. You're not actually retired. Sometimes you look also at the payee's age. If there's a big age discrepancy and the payee is not eligible for Social Security, maybe doesn't have another source of income, that can compel a payor to keep paying, because the court doesn't want to end up with this person on public assistance when there is, in fact, money to be had somewhere. If you look at other careers, there can be good faith early retirement. Police officers, carpenters, electricians. I've had a client who had both knees replaced, and he was in his early 60s, but he was not going back to his old job, and he didn't have any skills that were going to get him a similarly paying new job.
Wow.
So we were able to argue that it was a good faith retirement, even though it was early, and we sorted out a arrangement. Um, Judges have a mandatory retirement age of 70 in New Jersey. So we don't expect a judge to retire at 67. We don't necessarily expect lawyers to retire at 67 or doctors to retire at 67 if they're still, cognitively intact, because that's not at least for lawyers, not a physically demanding job. I can, I sit at a desk most of the time. I can do that past the age of 67 as long as this is intact.
If a recipient spouse moves in with a new partner but doesn't get married, does the alimony stop? What constitutes legal cohabitation in New Jersey?
That's a good question that we're still trying to figure out the answer to. There have been, in the last few years, some very interesting cases, landmark Supreme Court cases, about what does cohabitation actually mean? Is it just, I'm living with somebody? So the answer to that is no. Living together is both not definitive and also not enough. So you can be cohabitating but not living together full time, and you can be living together full time but not legally cohabitating. Because the definition of legal cohabitation is being in a relationship tantamount to marriage. In my opinion, and in many of the court's decisions, the most important factor is how intertwined are your financial lives? Are you supporting each other financially in a way that you would if you were married? Are you going on vacations together? Are you going to family holidays together? Those are also components of a cohabitation analysis. If you're living together, the idea is that you are reducing your actual costs, and it's not fair for the payor to be paying you money you don't need. It's particularly not fair for the payor to be subsidizing the life of this new romantic interest. In many MSAs, marital settlement agreements, cohabitation does not automatically terminate alimony, but it can call for a recalculation, because it may not be that just because the one partner is now cohabitating with somebody else and has reduced their need, it doesn't mean they've eliminated their need. So there's more calculation to be done.
But so if a payor loses their job or has a medical crisis, how quickly must they act to modify their obligation before they fall into that, non-modifiable hole?
Part of that depends, because now we're talking about post-judgment. So if they've already got an alimony order, it came either as the result of a trial or the result of an agreement. If it came as the result of a trial, it's always modifiable under certain conditions. Job loss and the inability to obtain a new job, you can come back and you can file an application to lower or terminate your alimony requirement. You can't do that until at least 90 days after you've actually lost your job. And you have to present to the court a good record of, I've been looking for work. Here's what I've been offered. Here's the jobs I haven't gotten a response to. I've gotten an offer, but it's $30,000 a year less than I was making. You've got to come in with a robust record of a good faith job search. If you come in and you've been diagnosed with a degenerative illness, if you've been diagnosed, you're undergoing cancer treatment. If you come in and you've been declared disabled, that's a slightly different analysis, because we look at, is that a temporary situation? Is that a permanent situation? If your change in circumstances is deemed to be temporary by the court, they may suspend enforcement of your alimony obligation without actually terminating or reducing your alimony, which means the arrears will accrue, but the court knows that you're not paying isn't in bad faith. You would pay if you had the ability to. You're temporarily without the ability to, so we're not going to, haul you into court on a regular basis. We're not going to, they don't suspend your driver's license anymore, but we're not going to do any of those things that we might otherwise do to try and compel you to pay. If your alimony order came as the result of a trial, those options remain open to you. Sometimes, if your alimony obligation comes as a result of a marital settlement agreement, it's non-modifiable. You take that risk. That is most often seen if there is a temporary term of alimony, a limited durational alimony, rather than open durational. If it's open durational, we almost always leave in a modifiability provision, because aging comes with its own set of concerns. If you've got a 4 or 5 year limited duration alimony, because we don't want you back in court every 2 years, we usually make that non-modifiable. So if you lose your job, all right, your arrears are going to accrue and we'll take care of that when you have a new job. But you've entered that non-modifiable agreement, knowing what your expectations are. And because there is an assumption, I'll say that you will still be able to work for the duration of that limited alimony.
Miss Alex, thank you so much.
Thank you.
Right. That's a wrap on today's episode of For Better for Court. Thanks to Ms. Alex Claps for breaking down the New Jersey alimony. For more information, visit HeymanFletcherLaw.com. Subscribe and join us next time for more insights to help families navigate these important decisions with clarity and care. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.